I thought y'all was saying I got to. That's a all right, we're gonna get started in a minute. Attorney Dean, are you there?
Yes.
We're gonna get started in 1 second. I'm just gonna have to use the dial-in. Okay, you just have to unmute yourself.
Ooh.
Not you, Mr. Rice, you're all set. I can hear you fine. I believe you hit *9 to unmute. P.O. Jackson, can you hear me?
Yes. Can you hear me?
Yes, perfect. All right, we're gonna get started with Mr. Rice's preliminary hearing.
Okay.
Good morning, I'm P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. It's a preliminary hearing concerning Rice Richard, number 137358. Today is November 19, 2025. This hearing is being conducted via video at the BOPP Central Office, New Haven Correctional Center. This is a public hearing. Public access to hearings available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Me?
Yes.
Richard Rice, 137358.
Thank you. We have a parole officer present. Can you please identify yourself for the record?
Parole Officer Jackson, residential unit.
And we have a counsel here today. Please identify yourself.
Yes, Hannah Dean on behalf of Mr. Rice. Good morning, everyone.
Good morning. This is a preliminary hearing, which is the purposes under Connecticut law is to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine the act is sufficient serious to warrant revocation of your parole, and to determine you should be held in prison pending further proceedings. The state, not you, has the responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole since Elysium will place you back on parole supervision. If I find probable cause and determine the act is sufficient serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is a reversal proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure for today. I'm going to redo your rights. Then we will review the parole violation charge. The state appeal is running against you. I will review and identify exhibits filed for the record. The state will have an opportunity to address the issue of probable cause and state of the allegations. After the state is finished, counsel will have the same opportunity. At the conclusion of the hearing, I'll inform my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure, sir?
No, ma'am.
Okay. You have important rights, right to have an attorney present. You have counsel here. You have a right to see the written notice of charges of violation. Did you receive the written notice?
No.
I just want to note, I did speak with my client. He indicates that when the PO came to serve him, that he was given paperwork to sign off on and was verbally, told the charges, but he reports that he didn't actually receive any paperwork in hand. Is that correct, Mr. Rice? What I just put on the record, you didn't receive any actual paperwork, you're saying, from parole?
No, I have no paperwork at all.
All right. So did you review it with your counsel? Did you review the evidence with Mr. Rice?
We have, but I do just think that it is worth noting. I think that probably is a bit of an issue if he didn't actually receive the copy. I mean, unfortunately, we got the evidence for this at, I think like 3:30, 4 o'clock on Friday. I thankfully was able to review it, but unfortunately, when I spoke to my client yesterday, he had no idea concerning some of the charges. He thought there were only 2 as opposed to the 4. So I do just want to note that, or he thought there were 3, I'm sorry, as opposed to the 4. I will note, we don't want to continuance at this time. I did just want all of that to be put on the record.
Oh, okay. Okay. So you have a right to review the evidence. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine reverse witnesses. Do you understand these rights then? Are you ready to move forward?
Yes, I understand.
Okay, so we will now review the charge. The state, your appeal is bringing against you, and information underlying each charge. So P.O. Jackson, if you please read the charges.
Yes, thank you. Charge 1, reporting. On 10/28/25, during reporting with your parole officer, you stated, "I won't be meeting with you when you come next month. It's pointless. This will be my last time meeting with you." Charge 2, behavioral management program. On 11/4/25, you failed to attend your anger management intake at MCCA at 8 a.m., despite being directed by Walterbrook staff to attend on 11/3/25. Charge 3, halfway house placement. On 11/3/25, at approximately 10 a.m., you signed out on an approved community pass for group at CCAR and was expected to return at 1 p.m. However, you failed to do so. At approximately 3:35 p.m., you returned to Walterbrook, being unaccountable in the community for approximately 2 hours and 35 minutes. On charge 4, mental health evaluation I'm sorry, I missed one for halfway house placement. On 11/3/25, you were observed on video yelling at Walterbrook staff, flailing your arms in the air, and getting in his face stating, "I don't give a fuck about you. I don't give a fuck about your family. Watch and you're gonna see." Staff attempted to create distance from you by walking away, and you proceeded to follow behind him in an aggressive manner, continuing to yell. Charge 4, mental health evaluation and treatment deemed necessary. On 11/4/25, You failed to attend your mental health evaluation at MCCA at 8 a.m., despite being directed by Walter Brook staff to attend on 11/3/25.
Thank you. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, parole violation notice, B, CT PCS condition, C, halfway house agreement, D, Walter Brooks incident report 1, E, Walter Brooks incident report 2, F, offender misconduct 1, G, offender misconduct 2. Exhibit H was not, video evidence was not received at within the 7 days, so that's not being taken into consideration today. Exhibit I, remand of custody order, and J is parolee rights. So I know you stated you did not receive the parole violation report and the other documents. Is that correct, sir?
Yes, I didn't receive none of the paperwork dealing with none of this. I have no paperwork dealing on none of this.
So do you want to move forward with the hearing today, or would you like a continuance so that you may receive all the documents?
We would, so in an effort not to delay, we would like to move forward today, but I would just request the parole, serve him with that paperwork as soon as possible.
I know the evidence was sent out, but due to the amount of time, it probably was not received in hand yet. So that's why, I mean, it is your option if you would like to continue, so you get it in your hand.
We don't want to continue. We
Okay.
wish to move forward. Thank you.
All right. So we have no witnesses today. So at this time, the state is going to have an opportunity, if they'd like to make a short statement, testify with respect to probable cause as to the allegations.
Yes, one moment. I see Mr. Rice is like holding up his
ahead.
hand.
I asked for the counselor about the situation about me not being able to go to the mental health situation.
Yes, we will discuss that. Did you want me to request a continuance today?
No, I would like to know why she's not here.
I explained to you yesterday, we were not able to contact her or not able to get her to come to the hearing yet. If this does proceed to a revocation hearing, I will contact her. What I had spoken to you about yesterday was we could either try and get a continuance to have her come in or proceed today, which was my advice. But it is up to you. If you wish to continue and we can try and have her come in, we can.
What does
Are
that
you
mean,
okay to
sir?
move forward?
I'm doing what you said. Go ahead.
Do you feel comfortable moving forward today? We need a verbal answer from you, Mr. Rice.
I guess, yes.
Okay, thank you.
I am going to swear in P.O. Jackson as well as Mr. Rice in the event you would like to speak at all today. So just please raise your right hand. You solemnly swear or sincerely affirm as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes, ma'am.
I do.
All right, so at this time, P.O. Jackson, would you like to say anything?
Yes, I just would, so to the first charge 1, reporting, I just want to say that in my first time meeting with Mr. Rice, he was definitely very adamant that moving forward, he will not be following his reporting instructions and meeting with parole on a monthly basis as he's been directed to do so. This officer attempted to end the conversation and say, all right, let's just figure that out when that time comes. He refused and stated, nope, let's figure that out now. Let's get to that bridge now. No need to figure it out later. I'm not going to be seeing you again. So I just thought that was worth noting. As far as his anger management and mental health evaluation, charges 2 and charges 4, as is stated in there, Mr. Rice was definitely well aware that he was expected to attend his intake appointments, and he just refused to do so, not just refusing to follow his PCS conditions. And as far as the halfway house placement, he signed out on a pass, though, to return, stating that he had more pressing matters going on versus returning to the program on time. And in regards to him yelling at staff, he was definitely aggressive. Staff attempted to walk away. He's following behind the staff member. Staff attempted to go into the main office to create distance. He still followed behind to a point where another offender had to grab him and hold him back. I just think that his short time at Walter Brooks' house, he's displayed a blatant disregard for his PCS conditions, and not willing to successfully complete the halfway house. That's all.
Thank you. So at this time, it is the defense's opportunity to like to respond and testify with respect to probable cause and severity of the allegations at this time.
Yes, thank you very much. I would first argue concerning charge 1 reporting that the probable cause standard has not been met. I would argue that nowhere in the evidence or on the PVR or in the testimony that was given does it state that my client ever refused to report or ever failed to report after being directed to do so. I would argue that the allegations here, which I will note my client does deny, do not meet the elements for the charge of reporting, and there is insufficient evidence for that charge. I will just note at no point do we have an evidence that Mr. Rice was given an instruction to report, on a specific date, at a specific time, at a specific location, and then failed to do so, which I would argue are the elements for that charge. As to the halfway house placement charge, I do want to ask my client, Mr. Rice, a couple of questions. Mr. Rice, concerning the situation that transpired on November the 3rd, when you allegedly got back to the halfway house late from CCAR, can you please explain the whole situation that happened there?
Okay, what happened was the individual that I was talking to, he was trying to elevate the situation to make it look like that the individual that runs the halfway house was in danger when me and the other individual that was late. Because I was late with an individual, it was two of us, it was two individuals. The same individual that's in that video where we're verbally going back and forth. If you look at that video, you'll see another dude coming around. That's what made the situation look like it was about to be a problem. I'm telling the individual on the side to back up so I could talk to him. He kept moving. So I'm like, yo, get out the way, because it's making it look like I'm trying to sit here and do something to him. And then the individual that was there that we was talking to, he was like, yo, what, you was gonna jump me? I said, man, I'm not gonna do nothing to you. I'm trying to talk to you. He sat there and tried to make the situation worse by asking the head person that was running the house, do you need backup? And I looked at him like, yo, do you even understand what you're doing? You're sitting here making the situation worse than what it was. When we came in the house, we was calm, collected. I was willing to accept the situation due to the fact that the individual that's walking around, if you look in the video, walking around, he lost his papers. So we had to go back to pick the papers up. I explained that to the head individual that's running the halfway house, that he left his papers. We went back to go pick his papers up, and we came back. That's what happened. As far as me talking about his family, all that, there's no verbal or no oral to this, so you can't tell what I'm saying. I never said none of that. I was talking to him. If you can see, if that was the case, I was there all night with him. I stayed there all night. The dude asked me, did I have any problem the next day? I said, no, I didn't have no problem with him. I don't have no problem with him. I didn't feel it was a problem. They're making this out of something that it wasn't.
Thank you very much, Mr. Rice. So I would just note that, Mr. Rice made those comments. Additionally, I would note concerning the portion of the charge, as he noted, involving the altercation with staff, I would argue that for that, there should be a no finding due to the lack of video evidence. As stated, I think that really is the thing that is kind of, alleging here that there was an issue. But as my client noted for the record, that wasn't the full situation. And we also don't have that video and evidence. Yes, Mr. Rice?
I'd like to say one thing. Excuse me, I don't mean to be disrespectful or anything, but I talk with my hands. So when I talk, that's the way it looks like I'm aggressive. I'm talking to him. I'm saying didn't no one put their hands on him. If that was the case, it would have had already took a curve. It wouldn't have been me staying there all night the next day, because I was there for a whole night and we was there together. We went outside and I was talking to him outside, the individual that I was talking to on camera. I'll just put it like this. I know the dude personally from the streets. He knows my family. I know his family. That's how that is.
Thank you, Mr. Rice. I appreciate that. And then I just also want to speak as to charges 2 and 4. Concerning those, I would just argue that the probable cause standard has not been met. I will note that there isn't evidence in the record that my client, received specific instructions to participate in the program and then willfully failed to participate. In fact, I will note the charges themselves indicate that he did participate in a group the day prior at CCAR. And there are reports, I would just note that there are a lack of reports from either MCCA or CCAR and evidence indicating that my client was discharged from those programs or anything of that nature. Furthermore, I do think that this was a genuine misunderstanding concerning the situation with the passes on November 4th. And I do just want to ask you a couple of questions about that, Mr. Rice. Can you please explain to us the situation that occurred on November 4th? So I will just note, if you can do me a favor, maybe and back up, when everything transpired on November the 3rd and you allegedly were late from the halfway house, what was the sanction that they gave you? What was the limitation that they gave you at that time?
They gave me 2 weeks in the house for coming in late, and I accepted. If you look at the video, since y'all clearly have videos, we walked in his office, both of us, because it wasn't just me coming in the house. I was coming in the house with an individual that went to the program with me.
Sorry, just a moment, Mr. Rice. I just want to make sure we answer these questions, and I'll turn it over to you to speak about all of this in more detail. So I do just want to know, as he stated, he was given a sanction on the 3rd for, I believe it was like a 2-week limited movement restriction or lack of pass restriction. So I will note that, Mr. Rice on November the 4th was, initially expecting to go to his 2 programs that day. However, there was an issue concerning the pass he was issued, which led him to believe that he was not permitted to go. So, Mr. Rice, can you just explain on November the 4th, with that pass early in the morning, can you explain to me the situation that occurred there and what you brought to Miss Rebecca's attention?
Okay, well, we'll back up. We'll back up all the way to Monday night when all this started off from. Monday night, when I got back, I took my sanction as far as me being in the house. I went upstairs. I went to go look for the pass. The pass was not there. So I'm like, all right, let me go back downstairs. I went back downstairs to talk to Rebecca and let her know that I didn't have a pass to go. I can't leave the house if I don't have a pass. If I leave the house, that would be either escape or scrounging, however you pronounce it. And that's the reason why I didn't leave. My situation as far as me going to the mental health and the anger management, it starts I had to be out of there at 8 o'clock. Well, she don't get into the house until like 9 something. And it's gonna take me like a half an hour to walk or maybe more to Whaley Avenue. So I'm doing the math on what's going on. So I'm like, I'm not gonna leave. I couldn't leave the house because if I leave the house, like I said, I gotta have a piece of paper to show them where I'm going. I had no piece of paper. So I tried to tell that to Rebecca before she left that night. She came in later on that day and asked me, Mr. Rice, why didn't you go to your program? I said, I did not have a pass. That's what I needed to talk to you about. She said, oh my God, that's right too. You did say that you wanted to talk to me and I left. She said, I'll take care of it. That was my fault. I said, no problem. I did not refuse. I don't even think my parole officer even knows why I'm going to mental health. Does she even know why I'm going to mental health?
Well, so Mr.
That's
Rice,
not part of, just continue with what you're explaining.
correct, but that was what I wanted you to. That's perfect. I think that you said what you needed to for that charge. And I would just also follow up and ask: was it your belief that if you had left the halfway house on the 4th without that piece of paper in hand, that you would have been reprimanded?
I would have been probably in jail quicker than anything because that would have been an escape.
Okay, thank you very much.
Papers. Right. I would have
thank you very much.
And I would also just note for the record that the individual he's referring to as Miss Rebecca was his case manager, I believe, at the halfway house. All of this being said, I would argue that these allegations aren't serious enough to warrant my client's parole being revoked. I do believe this is his first time being placed on special parole. It's not a situation where he's returning with new charges or left the program. Despite the difficulties he was facing, he was still trying, I believe, to comply with his parole conditions. Mr. Rice, concerning the specific charges here and the seriousness of these allegations, is there anything that hasn't already been stated for the record that you would like to say at this time?
Well, you never got to the point of me denying to my parole officer that I would never talk to her.
So I already argued that charge. I can state, for the record, as I noted before concerning charge 1, my client does contend that that wasn't the situation there. It sounded from his explanation that it was a situation where they were talking in circles. It was more so, I think he was discouraged. I don't think it was a situation where he was saying, I'm never going to report to you, point blank. It was more so like, I'm probably not going to see you again, because he, I think, was feeling discouraged. Is that correct, Mr. Rice, concerning that conversation?
Yes. Can I elaborate on that or no?
Sure, but just note that you know, only speak to that charge.
It's short. It's about that charge. First of all, the situation that occurred with me and my parole officer, it was about nothing because she was talking about nothing. You know what I'm saying? And I told her, I said, I'm not going to keep coming down here with all this back and forth. You know what I'm saying? I didn't even go through this the last time I was on parole. It seemed like she comes in the house and that's the way she is. So that's the energy she received. I never told her I have to come down there and see her. How am I not going to come see her? That doesn't even make sense.
All right, thank you.
Hi, I would like to say something.
Go ahead.
Okay, just to Mr. Rice's point really quick, he literally just stated it. He said that I'm not going to keep coming down here, and that's literally what he told me. He's not going to continue to meet with me. There was no misunderstanding. I attempted to say, you know what, let's just deal with that when we get there. No, there's no point to deal with that when we get there. I'm telling you now, I will not be meeting with you moving forward. I'm not sure where the misunderstanding with that statement would be, but he made it extremely clear that moving forward, he's going to refuse to meet with his parole officer. In regards to the attorney's statement about CCAR, he attended a group at CCAR prior to 11/4. That does not meet the requirements of him having to report to MCCA for a mental health evaluation and for anger management intake. No, there is no discharge report from MCCA because he never made it to the program to be entered into the system. That's why he needed to report there on 11/4 at 8 a.m. to begin the process. He refused to do that process. So how can he receive discharge report if he was never into the program?
Mr. Rice, just wait a moment. We will get an opportunity to respond. I apologize. Go ahead.
And you mentioned that one of the things was limited community access. Absolutely. Yes, but that is with full understanding. That's why it states limited. Limited community access means that does not include treatment, that does not include employment, and that does not include medical. That's strictly for job search passes. Okay, he was informed that this is strictly for job search passes. He did have a pass ready to go at 8 a.m. He refused to go. I just want to make that extremely clear.
Just a moment, Mr. Rice, I will respond. Just a moment.
In addition to charge number 3, halfway house placement, the incident with the staff member. If you were, you guys were having a conversation, and so only thing I want to know is when the staff member attempted to walk away and create distance, why did you continue to follow behind him, flailing your arms in a threatening manner when he attempted to move away from you so you can calm down, but you wouldn't allow that to happen? Why does someone need to hold you back from entering into the staff office? Thank you.
Thank you. All right, would you like to respond to anything?
Yes, if I may just start, Mr. Rice, and then I'll turn it over to you. So concerning charge 1, I would just note, regardless of the conversation that was had, my argument for that is that this doesn't meet the elements of reporting. He was never given an instruction to report on a specific date, time, and place, and then failed to do so. So I would just argue that that doesn't meet the elements for that specific charge. And then concerning the MCCA, I was more so making a record that my client didn't have an issue with going to treatment. He had just been in treatment the day prior without a problem. And he certainly, was not trying to avoid going to MCCA point blank. I think that, his testimony, he's under oath, was put on the record that it was, I think, a genuine misunderstanding where he had brought this to the situation and the attention of Miss Rebecca at the halfway house's case manager, had let her know, hey, I don't have a pass in hand. It seems at one point maybe one was issued, but he didn't physically have it. And it was his concern because he had just been sanctioned the day before for coming back late. It was his concern that he didn't want to leave the house without paperwork in hand, verifying that he was able to go. As he noted, he was concerned that maybe he would be considered an absconder status or something of that nature if he did not have the approved paperwork. And as noted, he did bring this, I think, to the attention of staff on the evening of the 3rd. And unfortunately, it sounds like the staff had somewhere to be. She left before he was able to fully, discuss that situation with her. And as he noted, she arrived to the program the following morning after the program had already started. And when he raised it with her there, she acknowledged, oh, I'm so sorry you were trying to talk to me about something. So I would just, indicate all of that for the record. I would also just note that I would argue, again, insufficient evidence concerning the situation with the staff member. Again, that video is not in evidence. Mr. Rice, is there anything I didn't just cover that you want to put on the record?
They're explaining that she just explained twice that there's two groups that I was supposed to go to. They're the same place. It's not like I'm going to two different places. I never had a pass to go anywhere, so I couldn't leave. So how are you saying that I blatantly just said I didn't want to go? So you mean to tell me I said I didn't want to go and I sat in the house knowing that I'm going to go to jail? That doesn't even make any sense. I couldn't go nowhere. You can't even sit here. Did you even talk to anybody about why I didn't go?
Okay,
You're just assuming.
Okay, Mr. Rice.
Okay, Mr. Rice,
I understand what you said. I understand both sides' points. It's kind of back and forth now. I understand.
This is what we were going through in the office.
Mr. Rice, just give it a moment, okay? Let the hearing examiner announce her findings, okay?
Yeah, I'll be right with you with my findings.
We've put more than enough info on the record concerning the charges, okay?
Excuse me.
Yes.
I have one more thing to say about the mental health situation.
I'm pretty sure we covered it. This is something different that you have to say than we didn't already say?
No, it's different. I didn't get to explain about the mental health. I'm asking my parole officer, do she really know why I'm going to mental health?
That's not what the charge is. The charge has nothing to do with her knowing about it. This is irrelevant.
Because I'm going to mental health because they want to know. They want to know why I keep coming to jail. They want to know why the fuck I keep coming to jail. Do you understand that?
Mr. Rice.
Do you fucking understand that?
You need to sit down right now.
Man. Get off me, man. Do you fucking understand that?
Mr. Rice.
Do you understand that?
You need to stop right now. You need to sit down, please.
We need you to relax.
I'm telling you what the fuck I'm going for. This bitch is lying.
You need to relax.
She's lying. She's sitting there lying. That's why you're
Mr.
doing
Rice,
this
you
shit.
need to have a seat, please, okay? Let the hearing continue. Please have a
She's sitting
seat. We'll
there fucking
discuss
lying.
all of this.
She knew why this is going on.
Mr. Rice, we need you to relax, please, so we can finish your hearing. All right, so what I'm going to do is I'm going to announce my findings. So regarding that charge one, I make a, regarding reporting, I make a no finding of probable cause based on the charge not meeting the elements. Regarding charge two, condition behavior management program, make a finding of probable cause on exhibits B, E, G, as well as testimony. Regarding charge three, I do make a finding of probable cause on halfway house placements based on exhibits B, C, D. Regarding charge four, I make a finding of probable cause, mental health eval. This is just based on evidence B, E, G. I do find the acts are serious enough to warrant revocation. This is a technical violation, so that means I'm going to schedule you to come back, and then we determine if there's a violation or not. So I'm going to give you a date. You're going to get everything in writing. I'm going to talk to your counsel. You come back, and we determine if there's a violation or not. So,
Mr. Rice, I will give you a legal call. We'll discuss all of this further, and I will have my investigator reach out to the halfway house, okay?
we will see you very soon, sir.
She knew where I was going. That's why. That's what I need to know.
Mr. Rice,
that's the end of the hearing,
stop talking,
sir.
please. This is the end of the hearing, please.
We will see you again very shortly, sir. Thank you, Tracy.
Thank you.
Thank you all. Have a great day.
You have an amazing day as well.
Thank you. Have a good day.
Hi. The inmate just went to use the bathroom. We'll be right back.
Okay, thank you.
All right, sorry about that.
That's okay.
Hey, Davis, I just sent that guy back, this Eagle, Alvarado, right, just walked in the door, just, he said right back down, tell me this came back down.
Morning, Mr. Alvarado.
Good morning.
Good morning. We're going to get started with your revocation hearing, okay?
Yes, ma'am.
Good morning. I'm P.O. Meissner, hearing examiner for the Board of Pardons and Parole. This is a revocation hearing concerning Alvarado Lewis number 327279. Today is November 19th, 2025. This hearing is being conducted via video at the BOPP Central Office in the Williamside Wolf City Correctional Institution. This is a public hearing. Public access to the hearing is available via video live stream. Could you please state your full name and DOC inmate number for the record?
Louis Alvarado, 327279.
Thank you. And you have counsel here today. Please identify yourself.
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Alvarado.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole. We can release you and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge. The state appeal is brought against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, you have important rights today. Right to have an attorney present. You have counsel here. You have a right to see the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
Okay, you have a right to review the evidence. You have a right to submit evidence for your case at this hearing. You have a right to call and examine voluntary witnesses to cross-examine adverse witnesses. Do you understand these rights and are ready to go forward?
Yes.
Okay, so we'll now review the charge. The state appeal is brought against you and the information underlying each charge. So charge one, release direction GPS. Your charging officer reported on the dates and times below. You failed to appropriately charge GPS unit, resulting in GPS shutdowns and unaccountability in the community. These are violations of your signed GPS agreement form. These are on 11/1/24. You allowed GPS unit to shut down 8:52 p.m. to 9:23 p.m. 9:23 p.m. On 11/7/24, you allowed a GPS unit to shut down from 8:46 p.m. to 9:26 p.m. On 11/8/24, you allowed a GPS unit to shut down from 3:27 a.m. to 4:31 a.m. On 11/16/24, you allowed a GPS unit to shut down from 4:08 to 4:43 a.m. On 12/8/24, you allowed a GPS unit to shut down from 12:29 a.m. to 4:54 a.m. and then again from 6:54 p.m. until 8:10 p.m. On 12/14/24, you allowed a GPS unit to shut down from 4:46 a.m. to 5:11 a.m. On 12/20/24, you allowed GPS unit to shut down from 9:08 p.m. to 10:55 p.m. On 12/25/24, you allowed GPS unit to shut down from 5:40 p.m. to 7:40 p.m. On 12/27/24, you allowed GPS unit to shut down from 9:44 a.m. to 9:54 a.m. and then again from 8:05 p.m. until 11:50 p.m. On 12/29/24, you allowed GPS unit to shut down from 10:42 p.m. until 11:37 p.m. On 12/31/24, you allowed GPS unit to shut down from 5:14 to 5:52 p.m. And then again from 10:35 p.m. until the next day, 1/1/25, 5:02 a.m. And 1/3/25, allowed GPS unit to shut down from 3:24 p.m. to 4:59 p.m. And then again from 6:43 p.m. until 7:04 p.m. On 1/4/25, allowed GPS unit to shut down from 10:46 p.m. until 12:34 a.m. and then again from 7:19 p.m. until 8:03 p.m. On 1/5/25, allowed GPS unit to shut down from 1:03 a.m. to 2:27 a.m. On 1/11/25, you allowed your GPS unit to shut down from 7:11 p.m. to 7:29 p.m. On 1/12/25, you allowed GPS unit to shut down from 2:52 p.m. to 3:02 p.m. On 1/13/24, you allowed GPS unit to shut down from 9:57 p.m. to 11:47 p.m. On all dates and times, your whereabouts of the community were unknown to parole officers, drug violation, or signed PCS conditions. Charge 2 curfew, your charging officer report on dates and times below. You failed to appropriately return to your parole approved residence before your 9 p.m. curfew. These are violations of your signed GPS agreement form. On 11/17/24, you failed to abide by your curfew. You arrived at your residence at 4:13 a.m. On 12/18/24, you failed to abide by your curfew. At this current time, GPS curfew is moved to 8 p.m. as graduated sanctioned by previous parole officer in an attempt to gain GPS compliance. You arrived at residence at 8:23 p.m. On 12/21/24, you failed to abide by your curfew. You arrived at residence at 12:45 a.m. On 12/23/24, you failed to abide by your curfew. You arrived at residence at 8:23 p.m. On 12/24/25, you failed to abide by your curfew. You arrived at residence at 3:16 a.m. Charge 3, obedience to the law. Your charging officer report on 3/19/25. You're observed by members of Hartford Police Department's Vice and Narcotics Unit engaging in hand-to-hand narcotics sales. You appear to be working with several other individuals, potentially stashing narcotics in nearby concrete block wall. As suspected drug-dependent individuals would approach you, you walk over to the concrete block wall, receive a bag of narcotics, and hand to said individuals. You were in a known area for open-air narcotic sales. Under surveillance of Hartford police detectives made multiple drug sale transactions. Essentially, you were charged by the Hartford Police Department for possessing controlled substance first offense, sale of narcotic substance, possessing intent to sell, dispense narcotics, conspiracy to commit, possess intent to sell, dispense narcotics. You arraigned at GA 14 Hartford. Probable cause was found. You had a $100,000 bond and an expected court date of 4/21/25. Charge 4 drugs. Charging officer reported 12/24/24. You tested positive for cocaine and oxycodone. Your sample was sent 12/24/24 to Premier Biotech Labs for verification. Premier Biotech Lab came back as well with positive results 12/28/24 for cocaine and oxycodone. In the state, is following the exhibits pre-marked for identification purposes. Exhibit A, signed statement, understanding, agreement, conditions of parole. B, remaining custody order. C, violation, notice of parole. D, parole violation report. E, state of Connecticut judicial branch pending case detail. F, BOPP decision information summary. G, signed offender misconduct reports. H, Hartford Police Department police report case ending in 6007. I, signed GPS agreement form. J, Al universal printouts. K, Biotech Labs printout confirming positive tests. Did you receive notice of parole violation report, and those other documents I marked? Did you review those, sir?
Yes, ma'am.
Okay, and council's filed the following exhibit that's pre-marked for identification purpose. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
Okay, we have no witnesses. I did receive the addendum from PCS. The addendum reported on 8/25/25, you were convicted of conspiracy to commit, possession, intent to sell, dispense narcotics, to the 13-month jail sentence with all the charges now leave. The US date on that was for 11/26 with a TS date of 9/25/25. So if now defense opportunity, if I'd like to speak to any of the evidence submitted.
Yes, thank you. And just in regards to charge 1 under GPS, I would note that under the January 13th, 24 date, we would submit there's insufficient evidence to support that, as he was not on GPS, I believe, at that time. This GPS agreement was signed on August 20th of 24, and there's no evidence to support that. In regards to charge 2 under curfew, similarly, the last date, December 24th of 25, you failed to abide by your curfew. That date has yet to occur, so we would submit there's insufficient evidence to support that. In regards to charge 3 under obedience to the law, the addendum is stated accurate, but I'd like to place on the record that the addendum was, my client disposed of his case on August 25th of 25. The addendum was submitted on November 3rd of 25 and not in compliance with the state regulation. It should have been submitted by September 15th of 25. There's no explanation here as to why it was submitted nearly 2 months late. However, just wanted to place that on the record. In regards to charge 4 under drugs, I would just again note that we have an allegation of that is almost at this point a year old, but at the time was a few months in, but it's one allegation of a positive drug test during a 7-month period of supervision. Nothing further as to the charges.
And you said the in charge 1, the date that you were arguing was 1/13/24, or it was
Yes.
that was the date that
Yes. It's the last date on the, I believe,
on the first page.
yeah.
Is there anything else?
No.
Okay, so I'll be right with you with my findings. All right, so what I'm gonna do next is I'm going to announce my findings. So regarding that charge 1, I do find you violated the condition GPS based on evidence provided in support of the charge. Exhibits A, G, J, I with a no finding on that 1/13/24 date, as GPS condition was form was not signed yet. On charge 2, I do find you violate condition curfew based on evidence provided, A, G, J, I. There's a no finding on the date of 12/24/25, if that's in the future. On charge 3, I do find that you violated conditional obedience to law based on your conviction of conspiracy to possess with intent to sell, dispense narcotics. You sentenced to 13 months jail, as well as exhibits A, E, and H that's provided as evidence by the state. On charge 4, I do find you violate condition drugs based on evidence provided A, K, and G. So that includes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to, let's start.
Yes, thank you. My client is 39 years of age. He's single. He does have one 9-year-old child. When he's in the community, he receives his primary support from his mother as well as his siblings, all of whom reside in the Hartford area. He does have his GED, and during the time period that he was out under supervision, he was scheduled to begin the Second Chance Culinary Arts Program, which is located in Hartford. However, he did not have an opportunity to begin that program yet. He was in the community for approximately 7 months, and during that time period, he was sponsored by a family friend. He had successfully completed Open Heart. He had successfully sponsored to his brother's house, located in Hartford as well. He has now been within the Department of Corrections for approximately 8 months. When he is re-paroled, he's asking to be sponsored to his brother, Ronaldo Alvarado, and that information is contained within Defense Exhibit 1. And he also has plans to pursue his education in culinary arts, to pursue that Best Chance program, Best Chance for a Second Chance program, as well as being open to all employment opportunities, as well as being open to all treatment recommendations. I would note that his parole officer did recommend an additional 9 months on top of his court sentence, but I would also point out That's the same parole officer that submitted an addendum nearly 2 months late. So we would be asking that he be re-paroled in line with his new court sentence. And I would just ask that we confirm that his EOS date has not moved.
It has not.
Has not? Okay,
No.
perfect. Thank you so much. Nothing further. I don't know. Mr. Alvarado, do you have anything to add?
No, ma'am.
Okay, thank you.
So I'll be right with you with my recommendation.
Okay.
All right, there are a few things I do want to put on the record. You were in the community about 8 months before you were returned to custody. You did receive the new conviction for possession with intent to sell dispense narcotic to the new 13-month sentence for that. You do have 2 prior criminal violations while on this period of special parole supervision. And it's the same behavior that you're currently on special parole for, which is sale of narcotics. So this seems to be a pattern that you have developed and have continued to do while you're on supervision. So that is kind of worrisome that you keep repeating the same behavior. You did receive 8 misconducts during the period that you were released back out. You are done with special parole on 7/17/26. As I stated, the EOS date for this is 4/11/26. Based on the information I have, I am going to recommend that parole be revoked, that you remain incarcerated until your special parole completion date of 7/17/26. This is approximately a year and 4 months. I'm going to present this to the parole board on December 4th. So the board's going to review it. So the board can let you out earlier if they'd like, so that they can let you out as soon as that board review date, if they'd like to. They can let you out anytime in between there. If they'd like to release you before, they may. You're going to get it in writing about a week after December 4th, what the parole board's decision is. So it would give you a re-parole date if they want to re-parole you, as well as conditions if they decided to re-parole you. Do you have any questions?
No, ma'am.
Okay.
The board review date again, I'm sorry.
The board review date is 12/4, December 4th. Like I said, you'll get it in writing. Is there anything else?
No, if you have any questions and you want to talk for it more, you can just give our office a call, okay?
All right.
Set up a legal call, okay.
So you're all
Hello.
set today, sir.
Mr. Meadows, yes, are you there?
You're all set.
Yeah.
Wish you the best of luck, sir.
All right, hold on. I think you're in the conference now.
Hello?
Yeah, this correctional counselor, Mr. Meadows is on the line now.
Oh, you have Mr. Meadows?
Yeah.
Okay, we can go to his case right now.
All right, I'm hanging up now. Thank you.
Thank you.
Yeah. Hello?
Attorney, Mr. Meadows?
Yes.
Hi, 1 second. I just need to make sure I have everybody who's participating today. I have your attorney here. You can hear us okay?
Yeah, I can hear you.
Well, nobody else is talking yet. I'm just making sure you can hear me good. Okay.
Yeah, I can hear you.
Mr. Meadows, I'm here as well. Attorney Dean.
Oh, hi.
And
Hi, good morning.
is P.O. Richardson, are you here?
Yes. Hi. Can you hear me?
I can hear
Yep.
you, yes.
Hi.
Yes, perfect. So we're all here. Mr. Meadows is going to be via phone call. We can't get him down to the hearing room due to McDougal Walker having an event running right now. So he is going to be via telephone.
Okay.
So we are going to get started. Is everyone set to begin? Okay. Good morning, I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. It's a revocation hearing starting Meadows Cody number 283524. Today is November 19, 2025. This hearing is being conducted via video at the BOPP Central Office in McDougal Walker Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Cody Meadows, 283524.
Thank you. And we have parole officer present. Please identify yourself for the record.
Parole Officer Richardson, Mental Health Unit for Hartford District Parole.
Thank you. And we have counsel here today. Identify yourself.
Good morning, Hannah Dean on behalf of Mr. Meadows.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of facts with each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better awaited evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole and release you and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to redo your rights. Then we will review the parole violation charge, state your PO is bringing against you, and we'll review and identify exhibits filed for the record. The state will have an opportunity to present a relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all of the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. Do you have any questions about the purpose or procedure, sir?
No, ma'am.
Okay, you have important rights today. The right to have an attorney present. You have counsel here. You have a right to see the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Do now review the charge, the state, your parole officers bring against you, and information underlying each charge. So, P.O. Richardson, please read the charges.
Charge number 1, GPS. On 3/19/25, you signed a GPS monitoring agreement agreeing to abide by the requirements of the GPS. On 4/5/25, you allowed your GPS battery to shut down from 1:28 a.m. to 3:14 a.m. This is a violation of the GPS agreement. Specifically, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. Charge number 2, obedience to the law. On 6/24/25, East Haven police were dispatched to a harassment complaint in a residential area. While en route, responding officers were notified that you were to be around the victim's house waiting for her. On arrival, East Haven police made contact with you. You reported that you had been texting the victim all day nonstop to get your money from her. Police made contact with the victim, who showed them over 100 text messages, phone calls, and voicemails that you had sent to her over the course of 24 hours. You were observed by East Haven police to be texting the victim every 30 minutes to an hour. In addition, police observed a video you sent the victim telling her that she is your property as long as she has your money. Based on your actions, you were arrested and subsequently charged under family violence for Connecticut General Statute 53A-183, harassment 2nd degree. On 6/25/25, you were arraigned at GA 23 New Haven and probable cause was met. Charge number 3, halfway house placement. On 3/19/25, you were placed at the Open Hearth halfway house and signed a halfway house agreement. On 4/29/25, you were observed by staff at Open Hearth smoking a cigarette in the bathroom of the halfway house. This is a violation of the written rules of the halfway house. Specifically, I may not use tobacco products within the halfway house. I may only smoke in designated areas at designated times.
Thank you. I did receive the addendum for PCS. So the addendum reported on 10/8/25, offender was convicted of harassment 2nd, received a 90-day jail sentence with an EOS date of 10/8/25 for that sentence. On 10/8/25, offender was also found guilty of violation of probation and sentenced to 11 months jail with an EOS date of 7/18/26 as of today. The addendum also reported on 10/2/25, Mr. Meadows received a Class A disciplinary report for a conspiracy to commit assault. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, signed conditions of parole. Remand to actual custody form is B. C, notice of parole violation. D, parole violation report. E, halfway house agreement. F, GPS monitoring agreement. G, allied universal event history. H, allied universal offender charge history. I, offender misconduct. J, incident report. K, East Haven Police Department case incident report. L, State of Connecticut District Branch pending case detail. M, board of pardons and parole decision information summary. N, board of pardons and parole rev summary. Additional evidence that has been added and labeled is Exhibit O, which order of probation, orders of protection. Exhibit P, arrest report and RT screen. Exhibit Q, VOP arrest warrant and probation motion. Exhibit R are admits, and Exhibit S is the DR history with the noted the 10/2/25 for 50 to commit assault DR. Did you receive notice of parole violation report, and those other documents I marked? And did you review them, sir?
Well, for the violation of parole,
Yes, just the evidence and the paperwork with the parole violations on it.
that you sent me, right, Erica?
The
Yes,
documents I
that would
just
have been
marked.
what your
Yeah.
PO sent you, correct?
Yes, I've gotten
Okay.
those.
Thank you. And counsel has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
Okay, we have no witnesses. At this time, the state will have an opportunity, if they'd like to present evidence, to speak to any of the evidence submitted. I am going to swear you in, P.O. Richardson, as well as Mr. Meadows, in the event you would like to speak. So can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, to help you God upon penalty of perjury?
Yes, I do.
Yes.
All right. So right now, P.O. Richardson, would you like to say anything in regards to the charges?
Not to the charges themselves, just reserved for background information at the end.
Okay, thank you. So I'm going to turn it over to counsel.
Thank you very much. Concerning, just very briefly, concerning charge 1 GPS, I would just note that the dead battery was for, I believe, just a couple of hours, and that did occur over the overnight hours. My client does report that he was asleep when that dead battery did occur, and that is why it was not addressed sooner. However, I will just note that that was unintentional. Concerning charge 2, obey all laws, I just want to put a couple things on the record. First, the addendum that was submitted is accurate. My client got 90 days to serve on the matter at docket ending in 633. I would also just note for the record that the addendum concerning his violation of probation sentence is also accurate, though I would make the argument that a violation of probation itself is not a new criminal charge or a new violation of the law. When a violation of probation is resolved in court, the defendant isn't pleading guilty to a new charge. They're essentially just admitting to a status, whether or not they're in violation. So I do just want to make that argument that it isn't a new criminal case, but nevertheless, we do wish to have that VOP considered at this time, as it has been incorporated into this violation per the addendum and evidence submitted. I just want to note this on the record now to avoid that sort of unfair situation where someone is re-violated at a later time for conduct that's known to PCS at the time of the current violation. I'm not stating at all that that is this PO's intention. I just want to make a record of it because that is something that our office has seen in the past. And then lastly, the halfway house charge. I would just note the allegation concerning my client smoking the cigarette. He does note that, he was, I believe, with 7 other individuals, he states at the time, and they also were smoking. And he notes that out of all 7, he was the only one that got written up. But that is it concerning the actual charges. And I would like to speak to his background at the appropriate time. Thank you very much.
Thank you. I'll be right with you with my findings. All right, so in regards to my findings on charge 1, I do find you violated condition GPS based on evidence that was provided, which is exhibits A, F, G, H, and I. Regarding charge 2, I do find you violated the condition obedience to the law based on your conviction of harassment second and received a sentence of 90 days jail. On charge 3, I do find you violated condition halfway house placement based on evidence provided, which is exhibits A, E, and J. That includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, we'll have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So, P.O. Richardson, if you'd like to at this time.
As noted in the recommendation portion of the parole violation report, this is Mr. Meadows' second violation of his special parole supervision. Both have been criminal violations, and so each time he has been returned to custody, it has been with new charges and new arrests. It is noted that this particular criminal violation was under family violence. It is domestic in nature, the harassment charge, and it is noted that his instant offense as to why he is on special parole in the first place is for a domestic violence offense as well. And so it was requested that the Board of Pardons and Parole take that into consideration.
Right, thank you. Turn it over to council.
Yes, thank you very much. I would just note for the record, I understand PO Richardson's comments. I do just want to note for the record that my client has, I believe, maintained that this was not an individual with whom he had any sort of, domestic relationship or anything like that. I did just want to note that for the record. Concerning Mr. Meadows, though, I will just note he's 42 years old, I should say, born and raised in New Haven, Connecticut. His primary support in the community is his significant other, Miss Brown. He also does have 5 children. Upon release of special parole in March of this year, Mr. Meadows successfully completed Open Hearth Halfway House and then was at the REACH program. He has prior history at Walter Brooks Halfway House and Cheney House. He reports participating in the Capital Workforce Best Chance for a Second Chance program to obtain his OSHA flagging and forklift certifications. He reports that he was searching for work and actively interviewing while in the community. While on parole, was doing psychotherapy, individual and anger management with a private outpatient therapist in Hartford. He also has treatment episodes previously, including at Foundation's inpatient program and doing the Explore program. My client has a number of medical concerns that he is very anxious to address once released back into the community. While out on parole, he was on a maximum contact schedule with good regularity of contact. He was, before being transferred to McDougall Walker, employed as a tierman at Robertson Correctional. Upon reinstatement of his parole, he would like to be sponsored by his significant other at the address we provided. As a backup, he's open to a halfway house in either New Haven or Hartford. If possible, he does prefer either Walter Brooks or Open Hearth. He has positive, good experiences at both of those. Mr. Meadows ultimately would like to procure independent housing and hopes to continue furthering his career. He wants to go back and study mechanics in the near future and obtain a driver's license. He's also interested in obtaining a flagging job. My client is open to any sort of recommended treatment, including reestablishing care with his psychotherapist and doing anger management. I will note that my client, Mr. Meadows, only had 1 misconduct during this period of supervision for the situation we already discussed concerning the dead battery. I am asking that you consider releasing him at the earliest possible release date. I believe that would likely take him into late winter or early spring of 2026, which I believe is, a significant sanction, being that he's been incarcerated since June of this year. Mr. Meadows, is there anything concerning your background history that I didn't include that you would like to put on the record at this time?
Like as what?
Just, you don't have to speak. It's just if there's anything I left out about, the good things you were doing while you were out that you would like to include at this time.
No, you covered it.
Okay, thank you very much. We're all set. Thank you.
All right, is there anything else from the state?
Not at this time.
Well, this would be it.
Yeah,
So
no,
if-
that's, yeah.
Okay,
Well,
okay,
okay, thank
to
you.
make sure. All right, so there's a few things that I would like to put on the record. Defender was in the community for less than 3 months before he was arrested on these new charges that are related to domestic violence. Did receive a new sentence, a 90 days jail for that. He did also receive a violation of probation, which is 11-month jail sentence that was not related to that charge. Does have a prior criminal violation that was noted by the state as well, and what that was domestic violence related on this period of special parole supervision. Did receive a misconduct. There is a history of domestic violence. It was also noted the offender, where evidence was provided showing the offender received disciplinary reports in jail for conspiracy to commit assaults. That was as recent as October 2nd. Taking everything into consideration, as well as the fact the offender is on supervision for domestic violence related offenses as well, I'm going to recommend that parole be revoked and that you be re-paroled for July 18th of 2026, which is approximate 1 year, 1 month period of confinement as a sanction. This is the EOS date on the violation of parole, violation of probation conviction date. So I recommend the following parole conditions: no consumption of alcoholic beverages, mental health treatment, behavior management program for domestic violence and anger management, no contact with your victims, BD, HDM, DDM, and MT. My findings are going to the parole board on December 4th. You should receive a official written decision from the board about a week after December 4th. The board can lessen my sanction. They can let it stand or impose a sanction longer than what I've recommended. You are on supervision until December of 2030, so there is still a significant period of time for special parole supervision. If the board wants a longer sanction than what I've recommended, you have a supplemental hearing, and the board would bring you back and they would provide you reasons why they may want to exceed my recommendation. During that hearing, they would give you an opportunity to respond to those reasons while in front of the panel. Do you have any questions, sir? You will get this in writing from us, what the board's decision is about a week after December 4th.
And Mr. Meadows, I can set up a legal call with you for that date so that I can report to you what the board decided if you'd like.
Yeah, I would like that.
All right. Thank you very much.
Okay,
Can I
so
ask
we
a
are all set for
question?
today. Go ahead.
I do have a question. I'm sorry. In regards to the condition for domestic violence programming, I
Yeah.
just want to if I could clarify, while he was out previously, it was ordered, he did complete successfully. Is this being reordered because of the new conviction?
That's it's up to you guys. If you would like to have him replaced in it due to the new
Okay.
conviction, he can redo it. Or if you decide just to place in anger management because he's completed it already, I mean, that's your decision out there.
Okay, thank you. I appreciate that.
You're welcome. All right, so you're all set. That concludes the hearing for Mr. Meadows.
Thank you. Have a great day, everyone.
Thank
Thank you. Have a good day.
Take care.
Goodbye.
Mr. Jackson there? There, Mr. Jackson?
Please hit *6 to unmute your phone.
Hello?
Mr. Jackson?
Yes, this is Mr. Jackson.
Oh, perfect. I have your Jones who's here. So we can get started with your revocation here, okay?
All right.
Good morning, Mr. Jackson.
Good morning.
Give me 1 second.
Yep.
Good morning. I am P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing. Sir Jackson Tyrie, number 259678. Today is November 19th, 2025. This hearing is being conducted via video at the BOPP Central Office in McDougall Walker Correctional Institution. This is a public hearing. Public access to the hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Tyrie Jackson, 259678.
You have counsel here today? Is it person?
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Jackson.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate parole, which means releasing and placing back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure, sir?
Oh, no, I don't.
Okay, you have important rights today. Your right to have an attorney present and you have counsel here. You have a right to receive the written notice charged with violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, I'm able to go forward. I understand.
Okay, so we will now review the charge, state your appeal is bringing against you, and the information underlying each charge. Charge 1, obey all laws, obedience to the law. Your charging officer reported on 6/26/25, Bridgeport Police Department was dispatched to Terrence Circle regarding a report of a domestic dispute. Dispatch was advised that the complainant victim reported to being assaulted by her boyfriend, Tyrie Jackson. The victim stated you were heavily intoxicated. You and her were involved in verbal argument while at a friend's house at the above address. The victim called an Uber to leave the scene in an effort to de-escalate the situation. The victim stated she exited the residence to enter the Uber and you physically prevented her from doing so by pulling her hair and shoving her. The victim returned inside the residence and called for another Uber. And when the second vehicle arrived, she entered the rear seat and attempted to shut the door. At the time, you reportedly pulled her hair again, attempted to drag her out of the vehicle. Victim stated he then punched her multiple times in the face with closed fists and possibly bit her on the forehead. Victim also stated that you took her phone and threw it, preventing her from calling for help. The Uber driver provided video footage to Bridgeport PD that clearly depicts you pulling the victim's hair and attempting to drag her from the vehicle while the victim was audibly crying. As a result, a warrant was issued on 7/23/25. You were charged with assault third, reckless endangerment second, unlawful restraint first, breach of peace second, interfering with emergency call. Charge 2 states on 7/23/25, while Bridgeport Police Department was doing an inventory of your person, you were found to have a clear plastic bag containing a white rock-like substance in your right front pocket, which tested and yielded positive for 0.5 grams of cocaine. As a result, you were charged with possession of controlled substance first offense. And the state saw the following exhibits pre-marked for identification purposes. Yes, Exhibit A, remand to custody order. B, state of Connecticut conditions of parole. C, state of Connecticut parole violation report. D, state of Connecticut notice of parole violation. E, state of Connecticut CT notice of employee rights. F, Bridgeport Police Department case insert reports ending in 2735, 4726, 3660, and 4739. G, state of Connecticut judicial pending case detail. H, state of Connecticut arrest warrant and application. I, offender misconduct report. J, GPS monitor agreement. And K is a video. Did you receive notice of parole violation report, and those other documents I marked? Did you review those, sir?
Yes.
Right. And counsel has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole statement. Do you need to continue to contain any additional evidence?
No.
We have no witnesses. I did receive the addendum from PCS. The addendum reported that on 10/15/25, the offender was convicted of assault third, received a 364-day jail sentence. He's also convicted of interfering with emergency call, reckless endangerment second, and breach of peace second, and received an unconditional discharge with all the charges nollied. The U.S. date on this conviction is 10/12/26 as of today's date, with a parole eligibility date of 8/19/26. So is now defense opportunity. Would you like to speak to any of the evidence submitted?
Yes, thank you. The only thing I would add in regards to charge 1 obedience to the law is that my client self-reported to his parole officer that he was in fact arrested. That he did have police contact, I should say. Then he was placed on GPS, and he was placed on that GPS for approximately 30 days. He successfully completed that and then was able to turn himself in to the Bridgeport Police Department. So I just wanted to put that on the record. In regards to charge 2 under drugs, again, I would just note that possession of controlled substance charge was nollied. Nothing further as to the charges.
Thank you. Great. So what I'm going to do next is I'm going to announce my findings. So regarding that charge 1, I do find you violated conditional bail laws, obedience to the law. This is based on your conviction of assault third and received a sentence of 364 days jail, and interfering with emergency call and reckless endangerment second, and received unconditional discharges with all their charges nollied. That includes the fact finding, charge 2, I do find you violated condition drugs based on evidence provided in support of the charge, which is exhibits B and F. That includes the fact-finding portion of this hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, thank you. My client is 46 years of age and single. He has 1 minor child who's 12 years old. He has 3 adult children as well. His community support consists of his mother and 5 sisters. He is a high school graduate of Central High School in Bridgeport. And during the time period that he has spent incarcerated, he's been able to utilize that time well by becoming a certified nurse's aide in 2023, as well as obtaining certificates in culinary arts, CervSafe. He was in the community during this period of release. I believe he was released on August 30th of 24. So he was in the community for approximately 11 months prior to this violation. And I do believe this is his first violation. He was remanded to custody on July 23rd of 25. During the time period that he was in the community, he was sponsored to his sister, Yolanda Tucker, the entire time. He was gainfully employed working at Reentry House located in Clinton Avenue in Bridgeport, and he was doing maintenance work there. He was employed there for approximately 5 months. Also gainfully employed working at Stu Leonard's, which is a seasonal employment, as well as working at Price Right in Bridgeport for approximately 5 months as well. Again, he self-reported the incident that led to his arrest. He was on GPS for 30 days. He had successfully completed that 30-day period. He was also placed on to provide urines, and he, I believe he had provided approximately 5 urines, and all 5 were negative. I would note that the GIS does indicate that he was at a low risk. Also noting that he was scheduled to begin outpatient treatment for anger management and substance abuse groups, however, had not yet begun those groups. He reports that he was also volunteering weekly with the Color a Positive Thought organization as well. When he's re-paroled, he's asking to be sponsored by Ella Benjamin. That information is contained within Defense Exhibit 1, as well as he does have some employment to return to, working that maintenance job. He does indicate to us that he's interested in furthering his nursing education, so that's something he would like to pursue. He is open and amenable to all treatment recommendations. I would note that his parole officer recommended that he receive a period of incarceration equal to his new court sentence. I don't have, let's see, the exact date that sentence is due to expire, but he has
10/12/26 at the U.S. State on the new conviction.
And then the TS.
Parole eligibility date is 8/19/26.
So we would be asking that he be re-paroled at the earliest date that he's allowed to do that. Again, this is the first violation. He was in the community for approximately 11 months. And again, he self-reported the incident to his parole officer and was able to successfully complete that GPS. He certainly is not a flight risk or anything of that nature. Thank you. Mr. Jackson, do you have anything that you would like to add?
Yes. I do take fully responsibility for my actions that's been taken. I just want to be able to get back home to my family, further my education, get back into society, working, taking any programs that's out there for me to help me get back with any counseling or anything. And I apologize to myself and to my family and to the state for even having to be back up in front of you guys like this. But that I do apologize and take actions for my accountability. That's what I want to say.
Thank you.
Thank you.
Yes.
All right, so there's a few things I'm going to put on the record before I make a recommendation. You were in the community about 11 months before your return to custody. You are on discretionary parole supervision currently for serious charges of attempted murder, assault first, criminal possession of firearm, intimidating a witness. So, I mean, there is a history of violence, and it is concerning that while on discretionary parole supervision, you are convicted of pretty serious, I consider serious, domestic violence related offenses, and received another 364-day jail sentence on top of your sentence you are currently serving already, which is 17 years to serve with 5 years probation. There are no prior violations on this term of supervision. You did receive a misconduct. As I stated, the EOS date on this was 10/12/26. You are EOSing off your sentence on 1/4/27, which will continue to move with our rec credit. Based on the information I have, I'm going to recommend that parole be revoked if you remain incarcerated until your end of sentence date of 1/4/27, which is approximately a year and 5.5 months sanction. You have 5 years probation to follow. My fines are going to the parole board on 12/4. So the board can lessen that sanction if they want to. They can release as soon as you can get out, as well as any other time in between your end of sentence date of 1/4/27. If they do choose to re-parole you, you will get that in writing, what your date would be and what your conditions would be if they do want to re-parole you. You will know, you'll get it in writing about a week after December 4th from the board. Do you have any questions?
No, thank you. I just appreciate for y'all giving me a chance to get back out in society. That's pretty much, like I said, I apologize.
You need to get involved in programming, hopefully. You are in discretionary parole, so you're eligible for programming in there. Hopefully you can do something, before you're released, because obviously there's some things you need to work on.
Right. I'll get into any programs that they got to offer. Yes.
So you are all set for today, sir?
Yeah, if you have any questions or you want to contact me after the December 4th date, I can tell you if the board accepted the recommendation, okay?
All right.
Okay, you're all set, sir.
Thank you.
Good day.
Good morning, Your Honor.
Good morning. Just give me a minute. He'll be right down.
Thank you. Good morning, Mr. Brown.
Good morning, Miss.
Good morning. P.O. Carrington, are you there?
Good morning, I'm here.
Perfect. All right, so we're going to get started with your rev hearing, sir, okay?
All right.
Good morning, I am P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Brown Jasm number 387354. Today is November 19, 2025. This hearing is being conducted via video at the BOPP Central Office in Garner Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Jasm Brown, inmate number 387354.
Thank you. We have parole officer present. Can you please identify yourself for the record?
Parole Officer Carrington with the Parole Mental Health Unit.
Thank you. This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is releasing you, place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state or parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present all relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure right now?
No, ma'am.
Okay. You have important rights today, the right to have an attorney present. Do you want to continue the hearing without counsel?
Yes, ma'am.
Okay, you have a right to see the written notice, charges of violation. Did you receive the written notice?
Yes, I have, ma'am.
Okay, you have a right to review the evidence. You have a right to submit evidence supporting your case. At this hearing, you have a right to call and examine voluntary witnesses to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, I am.
Okay, so you now review the charge the state or parole officers bring against you and the information underlying each charge. So, P.O. Carrington, please read the charges. You do not need to read charge 4 because no finding was made at the time of the prelim.
Charge number 1, residence on September 2nd, 2025. You left the Dana's House halfway house without permission from program staff or your PO. You failed to notify anyone of your whereabouts and have failed to comply with your parole approved residence. You're in violation of your signed parole condition of release direction. Charge 2, drugs. On September 20th, 2025, you voluntarily admitted to abusing ecstasy. The crack cocaine was taken out of that statement originally. You were using since the day you left the halfway house on September 2nd, 2025. Charge 3, halfway house placement. On September 2nd, 2025, you left the Dana's House halfway house without permission from program staff or your PO. You failed to notify anyone of your whereabouts and have been unsuccessfully discharged from the program. You are in violation of your parole condition of halfway house placement. Charge 5, problem sexual behavior treatment. On September 3rd, 2025, you failed to attend your CTPSB group in which you attend on a weekly basis at the same time and same day of the week. Due to your whereabouts being unknown, you have been unsuccessfully discharged from the CTPSB treatment. You are in violation of your signed parole condition of problem sexual behavior treatment.
Thank you. And the state has filed the following exhibits that were marked A through J at the time of the preliminary hearing. We have no changes to that. Mr. Brown, you stated that you did receive all the evidence that we noted in the last hearing, right? Is that correct?
I received everything.
The evidence that we went over at the prelim.
Say again, ma'am. Sorry.
I said you noted at the prelim you received all the exhibits that were A through J, the evidence.
Yes, ma'am. Yes,
Okay.
ma'am.
And do you need to continue the hearing to obtain any additional evidence?
Can you say again, please? Sorry.
Do you need to continue this hearing to obtain any additional evidence?
What you mean by that?
That means, is there any new evidence you want to gather or anything else you have? Okay.
No.
Okay, we have no witnesses today. So I am going to swear in Field Parenting as well as you, Mr. Brown, in the event you want to speak today. So can you please both raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
Yes.
Yes.
Okay, so at this time, the state has an opportunity, if you'd like to present evidence and speak to any of the evidence submitted at this time. You put your arm down, sir.
I don't have much to add other than what we already went over in the prelim. Jasm was compliant while he was at Dana's house. This is his first parole violation. The plan would be for him to return to Dana's house. So I'm just recommending a minimum of a 4-month sanction.
Thank you. So it's now the opportunity to respond to the charges. However, remember that you may remain silent if you so choose. Would you like to respond to the charges, Mr. Brown?
Yeah. All the charges is what it said there. I apologize for what I did, but I was doing good. I apologize for what I did, and it won't happen again. I'm truly sorry about the situation. It just didn't need for me to come back to jail. I could have went to a program or something, rehabilitation or something like that. It just like, I don't know. I felt treated unfairly that I had to come back to jail for a situation, but it's all right though. It made me a better person, made me think wiser, think better, stuff like that. So it's just like, I just gotta like be mindful who I'm around and stuff like that, and like just continue on a good path. If I'm on a good path, to stay on a good path, and don't think otherwise. Even though I haven't like seen my mom in a while and stuff like that, and haven't seen people in a while, they still gonna be around for me. Even though in my situation, I gotta deal with my situation as it is now to get it over with, and then when my parole and everything is all done with, then I could go visit my mom and stuff like that. Instead of just rushing out there to go see, just running out there to get in trouble or to anything could happen to me. I could die, I could overdose, anything could happen to me out there. That's why I'm just thankful I'm alive today, and that's about it.
Thank you. I appreciate your statements.
Mm-hmm.
So I'll be right with you with my findings.
All right.
All right. So regarding that charge 1, I do find that you violated the condition residence based on evidence provided, which is exhibits A and F. On charge 2, I do find you violated condition drugs based on evidence provided, exhibits A and D. That was only on the ecstasy use. On charge 3, I do find you violate condition halfway house placement based on evidence provided, which is exhibits A, C, and F. Charge 4 is not taken into consideration as no finding was made at the time of the preliminary hearing and no new evidence was provided. Charge 5, I do find you violate condition problems of behavior treatment based on evidence provided in support of the charge, which exhibits A, E, and H. I also take into consideration testimony that was provided at the time of the preliminary hearing regarding those charges. So that includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. This part of the hearing is to help determine what outcome I will recommend. So, Field Parenting, I don't know if you have anything else that you'd like to say at this time?
No, thank you.
Okay. Mr. Brown, would you like to say anything in regards to your release plan, what it might look like, and what things you plan on working on when you go back into the community?
Yes, ma'am. What I look forward to in the community is to continue doing my program, continue looking for work, staying out of trouble, stay away from drugs, try and go into drug treatment programs, and like continue doing groups with what's her name? I forgot her name.
Michelle.
Michelle. Yeah, continue doing groups with Michelle about drug addiction and co-occurrence and disorders and stuff like that. Staying on my medication that I've been doing, and that's about it.
Are you doing any programming at Garner?
I go to church service. That's about it.
Okay.
And I'm doing one-on-one.
You continue with your treatment at Garner? That's recommended?
Yeah.
Okay.
Yeah.
And you need a halfway house placement?
Yes, ma'am.
Okay. All right, is there anything else that anyone would like to add before I make a recommendation?
No, thank you.
Okay. All right, a few things I'll put on the record. Bender was in the community for only a period of 4 months before he was returned to custody. He did turn himself in. He doesn't have any prior violations or misconducts noted on this period of supervision. He does have a flat sentence that he's currently serving. And you are on discretionary parole supervision until April 2026. Based on the information that I have in today's hearing, I'm going to recommend that parole be revoked and that you be re-paroled for January 9th of 2026. It's about a 4-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, no contact with your co-defendant Braxton Watson, no contact with your victim VB, problem sexual behavior treatment, mental health treatment, medication compliance, no contact with minors, enhanced internet and device monitoring. My findings are going to go to the parole board on December 4th. You will receive an official written decision from the parole board about a week after December 4th. It's going to tell you what the board's decision is. It's going to tell you your re-parole date. It's going to tell you your conditions, okay? The board can lessen my sanction. They can let it stand, or they can impose a sanction longer than what I've recommended. If the board did want to bring you back for any reasons to have a supplemental hearing, we would notify you and you would come back for a supplemental hearing. That's only if they wanted a longer sanction than what I stated. Do you have any questions, sir?
No.
Okay. So like I said, your recommended date is January 9th. We'll see what the board decides on December 4th. Okay. Okay, so you're all set for today, sir. Thank you, P.O. Carrington.
Thank you. Have a good day.
Have a good day. Good morning.
Good morning.
Thanks. Good morning, Mr. Tate.
Morning.
Morning. I have your attorney here, so we're going to get started with your revocation hearing, okay?
Okay.
Good morning. I'm P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing for Anthony Tate, number 412036. Today is November 19, 2025. This hearing is being conducted via video at the BOPD Central Office in Osborne Correctional Institution. This is a public hearing, public access. This hearing is available via video live stream. Please state your full name and DOC inmate number for the record.
Anthony Tate, inmate number 412036.
Thank you. And you have counsel here today?
Good morning, Peter Matthews with the Public Defender's Office from Mr. Tate.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better or weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole and release you and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. Then we will review the parole violation charge the state your appeal is bringing against you, and we'll review and identify exhibits filed for the record. Counsel will then have an opportunity to present our relevant testimony. After considering all of the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, I do not.
Okay, you have important rights today, right to have an attorney present, you have counsel here. You have a right to see the written notice of charges in violation. Did you receive the written notice?
Yes, I did.
You have a right to review the evidence. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are ready to go forward?
Yes, I am.
All right, so we'll now review the charge, state your faults bring against you, any information underlying each charge. Charge 1, obey all laws, obedience to the law. You're charging officer report 85.5, you're observed by a passerby exiting a vehicle and striking a woman who was in the back passenger seat. The victim fled the vehicle and you left the scene. PD arrived to speak with the victim who stated that you punched her in the face. A warrant was issued for your arrest. On 9/10/25, you were arrested on the warrant and charged with assault third and disorderly conduct. And the state has filed the following exhibits pre-marked for identification purposes as Exhibit A, Connecticut conditions of parole. B, CTDOC remain in custody order. C, notice of parole violation fully right. C, parole violation report. E, decision information summary, rev summary. F, East Haven Police PD report / arrest warrant. Did you receive notice of parole violation report, and the other documents I marked, and did you review them?
Yes.
And counsel has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue the hearing to obtain any additional evidence?
I do not.
All right, we don't have any witnesses. I will put on the record, I received the addendum from PCS. The addendum reported on 10/23/25, you did plead guilty to assault third and received an unconditional discharge with a nollie on the rest of the charges. So it's now defense's opportunity to like speak to any of the evidence at this time.
Thank you. I'll be brief with regard to this stage. I just say, with regard to the charges, the sole basis of the violation warrant was the arrest of September 10th by warrant due to an incident from August 5th. Mr. Tate did enter a plea under the Alfred Doctrine and was sentenced to an unconditional discharge on October 23rd. I would note that all the charges in the warrant were misdemeanor in nature, and the case was resolved fairly quickly in court without the imposition of any additional incarceration or supervision of any kind. Mr. Tate does dispute these allegations, which is why he entered an Alfred plea. But given the remand, there wasn't a lot of incentive on him to resolve the case rather than contest the charges in court, which typically is a lengthy process. I would like to be heard again further at the appropriate time with regard to the sanction. Thank you.
Thank you. So I'm going to announce my findings with respect to that charge. So on charge 1, I do find you violate that condition, obey all laws, obedience to the law, based on your conviction of assault third and received an unconditional discharge. So that includes the fact-finding portion of this hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Thank you. So Mr. Tate, he is 31 years old. He was born and raised in Connecticut. The information regarding his childhood contained in the mitigation report does suggest he had a difficult childhood, but his family does still reside in Connecticut, and he has a close relationship with his grandmother, who's currently residing in Higganum. He has 3 young children with his girlfriend. They were all living together prior to his remand, and Mr. Tate is hopeful to be reunited with his children once he is released from incarceration. He does have an apartment in Hamden, where he was residing prior to his remand, and he is hoping to be re-paroled to that location when he is released. His grandmother is also willing to be a sponsor going forward if needed. Prior to his remand, Mr. Tate was working as a truck driver in Durham at 1-800-GOT-JUNK. He had been working there for approximately 5 months, and he did have a good relationship with his employer. Mr. Tate's hopeful that he will be able to get this job back when he is released from incarceration. He's also working on obtaining his Class B CDL license, which he thinks is going to be helpful with career opportunities in the future. And additionally, he's been taking classes to work on his GED while he's been incarcerated. He only has one section remaining. He's passed a bunch of those tests and only has one test remaining before he completes the GED. So he's anxious to get that completed as well. Mr. Tate understands that getting involved in treatment is going to be essential to his success going forward. Prior to his remand, he was referred to anger management, but then he was transferred to a different district before that counseling started. At the time of his arrest, he wasn't on medication or involved with any mental health counseling, as the individual therapy sessions did not continue after he was transferred to Hamden, but he does indicate that there is a mental health history, and he does believe that mental health counseling and prescribed medication for his mental health conditions are going to be very helpful to him going forward in helping him manage his symptoms. And he is anxious to get involved in that treatment when he's released. He thinks that is going to make a difference in him going forward. With regard to the incident that precipitated this remand, Mr. Tate did plead guilty under the Alford doctrine. As I stated, he does dispute some of these allegations. I would just note again, he was never facing any felony charges, and the misdemeanor plea was resolved fairly quickly and favorably to him. Presumably, the prosecutors analyzed the circumstances of the case and the evidence and felt that an unconditional discharge was an appropriate way to resolve it. I would note as well that after the incident, Mr. Tate did immediately contact his parole officer, left her messages that same day this occurred to inform her of the police contact. He continued to work with parole and cooperate with the supervision until he was remanded based upon the warrant approximately 1 month after this occurred. So he never attempted to flee or hide the incident from parole in any manner. At the time of the remand, Mr. Tate, he's been under supervision for over a year, and he appeared to be doing very well on supervision. This is the first violation. There is no additional noted misconduct at all in the PVR. Since his remand, he's been cooperative with corrections. He hasn't picked up any tickets, and he tells me he's engaged in anger management treatment through the Department of Corrections right now. He certainly is willing to continue with any additional treatment that's recommended, including anger management, domestic violence counseling, and as I indicated, he does want to get involved in mental health treatment as well. I'm going to ask him to be released on the next available date to continue his supervision. He's demonstrated a willingness to cooperate with parole. He has a plan going forward to address his mental health and try to ensure things like this don't happen, and he does well in the future. Mr. Tate, is there anything I didn't cover that you'd like to address at this point?
I had support letters from my workers at the job too, that I emailed to the email that they emailed.
I didn't get any support letters from your employment, Mr. Tate.
Okay.
But I would note he does tell me he has a good relationship with work, and he's planning on going back there when he's released.
Thank you. And how are you related to the victim?
She is my god sister.
She's your god sister, okay. All right, so I'm just gonna put a few things on the record, and then I'm gonna make my recommendation. You were in the community about a year and a month before you were returned to custody. You are on special parole till 2031. You don't have prior violations or any issued misconducts. You did receive the new conviction for assault third with an unconditional discharge. Your officers recommending the court disposition, as well as anger management programming in the community. Based on the information I have, testimony at the hearing, I am going to recommend that parole be revoked to be re-paroled for December 10th, of 2025. This is about a 3-month period of confinement as a sanction. I would recommend the following parole conditions: no consumption of alcoholic beverages, operation of a motor vehicle, behavior management program for anger management, mental health evaluation and treatment deemed necessary, and no contact with your victims A, M, T, B, and JW. My findings are going to the parole board on December 4th. So the board's going to review my recommendation, and then they're going to either accept what I stated. They can lessen it. It can be as soon as 12/4. That's as soon as you can get out. They can agree to my recommendation of 12/10, or they can make it longer if they want to. If they want a longer sanction, you would be notified. You'd have a supplemental hearing, and the board would want to talk to you about reasons why they may want to exceed my recommendation. Just so you know, that is a possibility. But you probably, if they agree with you, you'd probably be gone before you receive anything in writing. If you're still there, you will get it in writing for about a week after 12/4, noting what the parole board had stated. Do you have any questions?
No, I do not.
Okay, so then you're all set, sir.
Okay.
You'll
So
know
December 10th.
you'll know December 4th.
Yeah, 10th is the recommendation, but like was indicated, it's up to the parole board ultimately, but that's the recommendation, December 10th.
Okay, of this year.
Thank you.
Yes. Yes.
All right, thank you. Have a good
Okay.
day.
Have a good day.
Bye.
Thank you.
You're welcome.
And you're gonna, when you go out the door, you're gonna take out that.